Are you going to die one day? Do you want to take care of items before that happens, or do you want to leave huge headaches for your heirs? Do you want to be the parent who bestows upon your kids issues that leaves them, well, frankly, hating you? Well, my guess is probably not. My name is Kenneth French. I'm here with Vast Solutions Group, the nation's premier tax and financial engineering firm for entrepreneurs. We've got clients all over the country who need help on estate planning, and here we're going to explain some easy to understand estate planning techniques that hopefully you can take care of now versus later. You know, probate, or going through one's estate that frankly wasn't thought of before someone's death, it subtly reduces the value of many estates. It can take more than a year in some cases, and attorneys' fees, appraisers' fees, and court costs, and may even eat up to as much as 5, if not maybe even 10% of a decedent's assets. Probating a routine asset valued at maybe $400,000 could cost as much as, frankly, 20 or maybe even 30,000. What do those fees pay for? In many instances, routine clerical work. Few estates require more than that, to be frank. Heirs of small 5-figure estates may be allowed to claim property through an affidavit, but this convenience isn't extended for larger estates, most of our clients. So how can you exempt more of your assets from probate and its court costs, etc.? Here are some ideas. Now, joint accounts. Married couples may hold property as joint tenancy. Jointly titled property includes a right of survivorship and is not subject to probate. It simply goes to the surviving spouse when one spouse passes. Some states allow a variation called a tenancy by the entirety, in which married spouses each own an undivided interest in property with the right of survivorship. They need consent, by the way, from the other spouse to transfer their ownership interest in the property. A few states do allow community property with the right of survivorship. Assets titled in the way also skip the probate process. Joint accounts can still face legal challenges. A potential heir to assets in a jointly held bank account may claim that it is not a, quote, true joint account, but a, quote, convenience account where a second account holder was added just for financial expediency. Also, a joint account arrangement with the right of survivorship may be found inconsistent with an estate plan. POD or TOD accounts. Payable on death or transfer on death forms are used to permit easy transfer of bank accounts and securities and even motor vehicles in a few states. As long as the original owner lives, the named beneficiary has no right to claim the account funds or the security. When the original owner passes away, all the named beneficiary has to do is bring his or her ID and a valid proof of original owner's death to claim the assets or securities. Now, gifts for 2020. The IRS allows you can give up to $20,000 each, as many different people as you like, in a tax-free scenario. By doing so, you can reduce the size of your taxable estate. Gifts of over $15,000 may be subject to federal gift tax, which tops out at 40% and can count against the lifetime gift tax exclusion. The lifetime individual gift exemption is currently set at about $11.18 million. For a married couple, the lifetime exemption is now $22.36 million, if I recall correctly. Recoverable living trusts and these estate planning vehicles allow to do much over probate while living. The grantor, the person who establishes the trust, funds it while they're still alive, up to 100% of his or her assets, designating the beneficiaries of these assets as his or her death, at his or her death. A pour-over will can be used to add subsequently accumulated assets to your trust at your death, yet those assets poured into the trust at that time will still be probated. The trust owns assets that are the grantor once did, yet the grantor can invest, spend, and manage these assets while living. When the grantor dies, the trust lives on. It becomes irrevocable, and its assets should be able to be distributed by the successor trustee without having to be probated in any way. The distribution is private, as opposed to a completely public process of probate, and it can save heirs court costs and time. Now, are there assets probate doesn't touch? The answer to that is yes. There are all kinds of non-probatable assets. The common denominator of the non-probatable asset is a beneficiary designation, which allows these assets to pass either to a designated beneficiary or to a joint tenant, regardless of what a will states. Example, assets jointly owned with the right of survivorship, trusts, and assets held within trust, TOD accounts, proceeds from the life insurance policies, IRAs, 401ks, defined benefit plans. Make sure to list upon retirement account beneficiaries. When you open retirement savings account, such as IRA as an example, you're asked to designate eventual beneficiaries to that account on a form. This beneficiary form stipulates where these assets will go when you die. A beneficiary form commonly takes precedence over a will. Your beneficiary designations need to be renewed and reviewed, and they may need to be updated. You don't want your IRA assets, or for example, going to someone no longer you trust or love. If you're married and have a workplace retirement plan, such as a 401k, etc., your spouse is the default beneficiary of the account holder under federal law, unless he or she declines to be so in writing. Your spouse is automatically entitled to receive 50% of the account assets should you die, even if you designate another person as the account's primary beneficiary. In contrast, a married IRA owner may name anyone as a primary or secondary beneficiary without spousal consent. To learn more about strategies to avoid probate, consult an attorney or a financial professional with solid knowledge of estate planning. This is very important. Now, we can be one of those groups. You can check us out on the web at www.vastsolutionsgroup.com or give us a call at 888-808-8278. We have people internally. We have people who are strategic alliances who can help us, or we can work with your existing estate planning advisor. We're happy to help. We've got clients from New York, Florida, California, to Washington State. We're here to help small business owners, anyone who's getting prepared for retirement or who's in retirement. Thank you for taking the time to watch this video. Hopefully in some way it was helpful. Hopefully in some way we will be able to help you or someone you know and love to better position themselves for the future. Once again, Kenner French, thank you very much.